Sending EU personal data abroad without proper safeguards? That's a fast track to massive fines and privacy nightmares. But GDPR provides the tools to navigate cross-border transfers compliantly. First, a disclaimer. This video is for informational purposes only and does not constitute legal advice. If you would like personalized guidance, you can contact our team or other qualified professionals. Hey everyone, Robert here, a legal consultant, licensed tax advisor, and founder of Kyroptera Consulting based in beautiful Slovenia. We've assisted numerous businesses in securing international data flows, avoiding penalties while keeping operations smooth. Today, we're tackling GDPR international data transfers. How to handle cross-border compliance without the headaches. Ever shop online and wonder where your EU data ends up? GDPR demands equivalent protection outside the EEA, that is the European Economic Area, which includes EU plus Iceland, Liechtenstein and Norway. Let's break down the rules step by step. Let's start with the general principles. Under GDPR, you can only transfer personal data outside the EEA if the destination offers protection that's essentially equivalent to EU standards, as outlined in Article 45 of the GDPR. This applies to everyone handling EU data, so you must assess every cross-border flow, like sending customer information to a US server and implementing safeguards if there's no adequacy decision in place. Without them, transfers are simply prohibited to protect individuals' privacy rights. Why does this matter? Imagine a European e-commerce firm using cloud services in Asia. If that country lacks strong privacy laws, the data could face risks from government surveillance or breaches. GDPR requires controllers and processors to evaluate these threats upfront, ensuring transfers align with core principles like lawfulness, fairness, and transparency. For practical steps, begin with a data mapping exercise to identify all your international transfers, from employee records in global HR systems to marketing data in overseas analytics tools. Challenges often arise when laws conflict, such as US surveillance requirements clashing with EU privacy expectations. To navigate this smoothly, conduct a Transfer Impact Assessment or TIA early. It's more than a checkbox, it's a vital tool to mitigate real threats. Even smaller firms can manage this with resources from the European Commission. Take a real-world example. A tech company moving user data to India without safeguards risks violations, since India lacks an adequacy decision. Instead, they should use approved mechanisms to stay compliant. By prioritizing these principles, organizations not only avoid GDPR non-compliance risks, but also foster ethical data practices. Now, on to adequacy decisions, one of the simplest ways to transfer data safely. These are official recognitions by the European Commission that certain countries have sufficient data protection laws, allowing seamless transfers without additional steps. The Commission evaluates a country's laws, oversight bodies, and international commitments to confirm essentially equivalent protection. The benefits are clear. It reduces administrative burdens, as you don't need extra contracts or assessments for these destinations. However, adequacy isn't set in stone. The Commission reviews them every few years. For instance, the EU-US Data Privacy Framework was established to address surveillance concerns, requiring US firms to certify annually and commit to principles like data minimization. Here are some practical tips. Regularly check the Commission's adequacy page for updates. If your partner is in an adequate country, document that decision in your records. And for partial adequacy like Canada's, which covers only commercial organizations, always verify the scope. This mechanism keeps global operations running smoothly while upholding privacy standards. Let's focus on two key ones. Standard contractual clauses, or SCCs, were updated on June 4, 2021, and offer modular options for scenarios like controller to controller, or processor to processor, or controller to processor, and vice versa. They legally bind the data importer to GDPR standards, such as security processing and breach notifications. If a TIA reveals extra risks, add supplementary measures like encryption. Then there are binding corporate rules, or BCRs, ideal for multinationals. These are internal rules approved by a supervisory authority, making them legally binding across the group, even in non-EU countries. They cover everything from data transfers and protection principles to liability, compliance monitoring, compliant procedures, and staff training. Together, these safeguards enable safe GDPR international data transfers without halting your business momentum. Of course, ignoring these rules comes with serious risks. Non-compliance can trigger fines up to 4% of your global annual turnover, or 20 million euros, whichever is higher. We've seen this in action with Meta's 1.2 billion euro penalty in 2023 for inadequate US transfers, not to mention the reputational damage and potential lawsuits from affected individuals. Emerging challenges add complexity, like diverging global laws with data localization requirements, or AI data transfers coming under greater scrutiny in proposed 2025 GDPR amendments. Plus, the EU Data Act, effective from December 12, 2025, introduces new rules on data sharing for connected devices, which could impact cross-border flows. To stay ahead, adopt smart strategies, conduct regular TIAs, use certified tools, keep informed on regulatory updates, and consult experts to adapt your approach. This proactive mindset helps mitigate risks amid evolving regulations. To wrap up the key points, transfers require equivalent protection outside the EEA. Rely on adequacy decisions for safe destinations, and use safeguards like SCCs or BCRs elsewhere. Always map your data flows, perform TIAs, and stay updated on frameworks such as the EU-US DPF and the EU Data Act 2025. Getting this right means you protect privacy, avoid penalties, and thrive in a global market. Navigating GDPR international transfers turns borders from barriers to opportunities. Respect rights, innovate safely. If this guided your cross-border strategy, like the video, share it, and subscribe for more compliance insights. Explore our Knowledge Center for resources. The link is below. Thanks for watching, and remember, compliance with the law prevents the flaw. Till next time.